We all know about the provision of Section 45 of the Indian Evidence Act, that is opinion of expert. Let me begin this video as far as examples are concerned. Mr. A is a doctor. He is pediatrician or he is an orthopedic. The case is related to the death of the person by heart attack. Now the question is whether the experience of that doctor Mr. A is related or relevant in respect of the death of that person by heart disease. Because Mr. A, who is doctor, is not at all specially skilled person as far as the heart related disease are concerned. So can that opinion of Mr. A be considered as an evidence? This is the one question. Second example, suppose Mr. B is an engineer. His expertise is in respect of factory laws. The case is related to the infringement of the copyright of the drawing of a machine. Then can his opinion be considered as an expert? The same question arises because he does not have any expertise or he is not specially skilled as far as intellectual property laws are concerned. He has expertise in factory laws. Whether he can give an opinion as an expert or his opinion can be considered as an expert to help the honorable court to adjudicate the matter. This is the content of this video. Let me go ahead in this regard. Section 45 of the Evidence Act, there are 5 points mentioned therein. 1. Foreign law, science, art, identity of handwriting and fingerprints or finger impressions. When the court has to form some opinion in such points or point, then court is required to take the help of some expert. There is one line in the provision which says that the opinions of persons who are specially skilled, this term specially skilled is very, very important. In such mentioned points, as I have just mentioned, these 5 points are relevant, meaning thereby if the person who is specially skilled in the points mentioned in the provisions of Section 45, then his opinion is relevant. Now, Honorable Supreme Court, in the case of State of HP, Himachal Pradesh versus Jailal and others, AIR 1999, Supreme Court 1318, has discussed in detail about the expert's opinion and who can be considered as an expert and everything. Let me discuss this judgment in this regard. First point, who is called an expert witness? An expert witness is one who has made the subject upon which he speaks a matter of study, practice or observation, and he must have a special knowledge of the subject. This is observed by Honorable Supreme Court in para number 13 of the judgment. The expert must have a special knowledge of the subject. So the answer of these 2 examples, if the person does not have any special knowledge of the subject, he cannot be considered as an expert. This is the first point. Second point, what does section 45 lay down? Honorable Supreme Court has observed in para number 17 of the judgment that section 45 lays down the opinion of experts are relevant facts. Therefore, in order to bring the evidence of a witness as that of an expert, it has to be shown that he has made a special study of the subject or acquired a special experience therein, or in other words, he is skilled and has adequate knowledge of the subject. Even this is the answer of our examples. If that person does not have special knowledge, if that person does not have any special experience, he cannot be considered as an expert as far as the factual part is concerned of any case. Third point, whether an expert is a witness of fact. In para number 18 of the judgment, Honorable Supreme Court answers that no, expert cannot be considered as an witness of fact. An expert is not a witness of fact. His evidence is really an advisory character. Thereafter, in para number 18, in the same paragraph, Honorable Supreme Court answers one question. Then, what is the duty of the expert witness? What is the duty of the expert witness? The duty of the expert witness is to furnish the judge with the necessary scientific criteria for testing the accuracy of the conclusions so as to enable the judge to form his independent judgments by the application of this criteria to the facts proved by the evidence of the case. So, it is the duty of the expert to help the judge to furnish some necessary scientific criteria so that court may consider this and court may give the judgment in this regard or with the help of such expert opinion. Next point, whether a report of expert goes in evidence automatically. If Mr. A gives an opinion, then such opinions becomes an evidence automatically in any case. In para number 19 of the judgment, Honorable Supreme Court says no. The report submitted by the expert does not go in evidence automatically. He has to be examined as a witness in court and he has to face cross-examination. The expert has to be in the witness box and after being in the witness box, he has to face the cross-examination. This is what Honorable Supreme Court says in this judgment. Friends, I believe that you like this video. If you like this video, please don't forget to subscribe my channel. Thank you very much.